Hey, my trendies, trendsetters, and my trendy tribe. How are y'all? Mic check, 1 2 1 2. Let's make sure I am able to get through. I see my thing vibrating. That's a good sign. Can y'all hear me? I have to check. I don't trust StreamYard. I'm waiting on it. I know. I'm waiting on it. Yes. Oh, I see it. Cynthia, thank you. Okay. For the replay gang, I will timestamp when I actually start talking about the documents. I do greetings and I have a couple of things. I do announcements first. So I will timestamp it. You don't have to go through all this. All right. First of all, thank y'all. I got my little certificate for 400,000 views. Thank you so much. I greatly appreciate y'all for coming to the channel and coming back. So thank you so much. Trendy tribe members, y'all see I got the little scroll now for you to say thank you. I appreciate y'all. Okay, Breast Cancer Awareness Month for October. Let me drop the link. Hold on. These are free to anyone that has the link. Normally my live sketch art goes just to the Trendy tribe members, but I am making sure this stays free. This is not limited to October. I just probably won't be announcing it after October, but the link will stay up either way. So I'm dropping the link for that. And okay, let's see what else we got going on here. Okay, let me say hello. All right. Uh-oh, hold on. Hey, Stacy, thank you for joining the Trendy tribe. Thank you. I appreciate you. Welcome. Okay, let me see. Oh, my mouse is being... Oh, StreamYard's probably going to boot me throughout the evening. I will come back up. We won't skip a beat because my documents are up on a different screen. They're not loaded into StreamYard. So I'm just going to blip out, come back in. We're going to keep it moving because StreamYard be StreamYarding. Okay, let me see here. My thing is scrolling crazy. Y'all, this is crazy. I know y'all don't. I'm trying to get to the top, basically, in case you wonder what the heck I'm doing. Okay, let me see here. Hey, Patricia Dyer, how are you? Hey, Cheryl Randall, Soul Star Music Lover, Mary Hooks. Oh, Cheryl, welcome to the Trinity Tribe. Okay. Hey, Jesse Bradley Lewis. Hey, Shirley Terry, Cynthia Arrington, Cynthia Scott, Linda Gamble, the YouTube MVP. Hey, Mary Willis. Oh, thank you, Mary. I appreciate that. Hi, Ann Green. It's Chrissy time. Yeah, shout out to It's Chrissy time. Linda is Chrissy Timer in the Mod Squad. Hey, Veronica Monroe. Hey, Shan. The Eagle has landed. Shan is in the Mod Squad as well. Let me see. Hey, Carolyn Jean Warren. Thank you so much. Oh, I appreciate you. I appreciate you. Thank you. Hi, Tamara Allen. Hey, Joyce Miles. Hi, Maria Hardy. Let me see. I see my sis 41 Fits in here. Okay. Did you make it home yet? 41 Fit is a content creator and part of the Mod Squad. Let me see. Hi, Valerie Bella. Hey, let's be clear. Hi, Denise Coleman, Sylvia P. Let me see. Hey, Francois, welcome back. Hey, Tracy Williams. Tracy got the breast cancer awareness list already in that profile. Hey, Titi. Hi, Latisha Hunt. Hey, Stacy. Yes, finally. And you caught a good live, Stacy. This is one you want to catch. So ready for this live. Thank you for hitting the like button, Francois. Oh, food in the oven. Come on. Y'all get settled in with those snacks now, because we're going to go through it. Let me see. Hold on. Hey, LS. Good to see you again. Hey, Annette. Hi, Rashida. Acting like Martell up in the chat, just squatting all day. Come on, Rashida. That's cute. Hey, how I see it, TV. She says she's early, about to pull out and work and drive home. Thank you. And I know my minds probably already know, but how I see it, TV, are you a content creator? Oh, snap, LS. Thank you for the super chat. Happy Friday. Thank you. And thank you for the congratulations. Let me see. StreamYard, don't you do me. Hey, Queen 3K. Oh, PK Joe in the house. Okay. Lisa, Taisha J. Hey, Taisha J. How are you? Yes. Hey, Lisa girl. Let me see. Cinnamon Swirl, one of my Leo sisters. Yes. Hey, Gloria Strickland. Hey, Irene Bay. Let me see. Hey, MC Geechee, Lori Harrison. I got you, Lori. The Real VB, how are you? Hey, Patricia T. Hey, Daphne Brown. Tammy Van. Yes, I see you. Hey, Lizzie Wheeler. Hey, Joy S. Pick. Good to have you back. Let me see. Hey, Joe. Yes, we back. Hey, Kelly Davis. Hey, Mary White. Hey, Ebony Dancer. Kim Agnew, how are you? Hey, Sheila Jackson. There's Phyllis Crawford. Not for nothing. Miss Cheryl Seattle in the house. Hi, Kamei Ingram. Hey, Reader. Hi, T. Marie. Let me see. Okay, I'm going to go down a little bit further, y'all. I know y'all bearing with me. Hey, Girlfriend Chronicles. She is a content creator as well. Hey, Sexy Chocolate. Hey, Queen's Jaja. I think Queen's Jaja is a content creator. Hey, Carolyn Jean Warren. Sandra Sanderson, hey. Sorry, say hi to Thee. Hi, T-Gray, Toffee Mocha. Hey, D Brown. Okay, hey, Sweet Rose. And hey, Vi Gordon. I'm so sorry if I didn't get to say all the names. Y'all, it's a blessing. This was not a problem. It's a blessing, but y'all know I see y'all and I appreciate y'all for being here. Okay. Let's start getting down to the brass tacks. All right, let me get this up. What do I want to take off? Okay. So y'all know we're here for Zen Gardens Part 5. If you haven't seen the other parts, I do still think they're worth watching for background. I won't be able to address questions that were kind of already addressed in the other parts unless it just kind of flows with what I'm already doing. But for the sake of the documents I'm reading, I suggest watch the other parts. Speed me up. You can speed up the thing. You don't have to watch me in normal speed. Okay. And to provide some background, Scholt, which is Marsau Scott's. I'm saying Marsau's company because Tisha technically is the 85% owner, but I mean, come on. Marsau Scholt sued Zen Gardens. They were the original plaintiff. Zen Gardens, who had kind of taken their L and their loss, and I think had kind of walked away from it all and just was going to go about their business was like, oh, okay. So now they countersued them. So they are both a plaintiff and a counter plaintiff, and then a defendant and a counter defendant. Okay. So that's the background. Shout out to Black Titanic. She's been boots on ground. She kept this at the forefront, piqued my interest. Wouldn't have known a lot about this lawsuit at all if Black Titanic had not been out there already trying to bring it to us and be like, don't listen. I mean, we weren't listening to the Scots, but she was like, here's some black and white. Do not listen to the Scots. Let me put my banner up. Okay. What else was I going to say? Oh, and just shout out to all the content creators that, shout each other out. I appreciate it. Here for Hot Tea did shout out my, I think my very first video that I started was in Gardens. If not, it was the part 2 with Marsau and his I Do Not Recall track. And that thing was sitting at 600 views, and Here for Hot Tea shouted me out. I appreciate it. Y'all probably wouldn't even have seen this if it wasn't for everybody supporting everybody. So I just thank you. All right. So let me get the documents pulled up. Share the screen. Again, if I get blipped out, I'm coming back. I shall be back. Because it's nothing new with StreamYard. Oh, hold on. Is that somebody else? Maria Hardy, welcome to the Trendy Tribe. Okay. Oh, this information is public knowledge. I will just be using this information for the purpose of criticism, commenting, reporting, and research. All right. Okay. Let's share. Let's get up here. Okay, let me tell you what we're looking at first. So we will be going back and forth between a few documents. We're going to go back and forth between the actual, let me get the name to make sure I say this right. This is Zen Garden's brief in opposition to the plaintiff's motion for a partial summary judgment, okay? We're also going to look at the actual contract for a couple of references. We will be looking at, the notice of default letters, and we're going to look at the actual proposal that Scholt sent in to Zen Gardens, because it matters. And I am laughing at them. So yes, I laugh. This is not going to be a straight read through and monotone. I can tell you that now. All right. Okay. So I have my notes because some of these, as you can see, it'll just say undisputed and it won't tell you what it's referencing. I already got my notes. So I can tell you exactly what they're disputing or not disputing. Okay. So let me make sure I have everything. I won't be able to look down at my phone too much and everything, just in case I'm not saying anything will come through, but just bear with me. All right. So the first part, Zen Gardens. This is Zen Gardens dispute or undisputed. This is their brief. Okay. So Zen Gardens says they dispute number 1 of Scholt's partial summary judgment request. It says Mr. Shaw, and Mr. Shaw is the primary face of Zen Gardens for this case. Mr. Shaw does not hold himself out as a civil engineer. He does, however, hold a bachelor's degree in civil engineering. He also received a master's degree in construction management from Stevens Tech in Hoboken, New Jersey. Okay. Valerie Owens, welcome to the Trendy Tribe. Okay. So the next part, this is where Zen Gardens does not dispute these next few claims. So it says, they don't dispute that Shaw has never held a professional engineer license. He never tried to say he did. He does not hold one. They don't dispute the fact that Scholt says Zen is composed of 6 members, Shaw included. That is a fact. Zen does not dispute the fact that Zen has no employees. They have members, managing members. They do not have employees. Zen also does not dispute the fact that Zen is managed by Zen Gardens Manager LLC, with Shaw acting as sole managing manager of Zen Gardens Manager, effectively making Shaw the sole managing member of both Zen Gardens Manager and Zen Gardens LLC. They also don't dispute the fact that the project at issue is an apartment complex and is located at 1709 Slaughter Road, Madison, Alabama. They also okay, I think okay, sorry, y'all. They also don't dispute the fact that Mr. Shaw operates under a number of entities, including Zen Gardens Manager, and Premier Project Management, all of which are relevant I'm trying to see, how do I see this whole thing? Hold on, y'all. Hold on. I don't know why. Okay, all of which are relevant. This better not be an issue. Sorry, I'm trying to see my little pop-up notes. All right. Now, the first part that Zen Gardens, or another part that they dispute, is when Scholt tried to say, during the building of the apartment complex, PPM, which Shaw owns, served the purpose of ensuring construction went according to plans and specifications with the right quality and within schedule. In other words, PPM, which i.e. Shaw, would oversee the general contractor, Scholt, and report back to Zen, which they're trying to say he's reporting back to himself, and the sole managing member, Zen Gardens manager. And what Zen is saying is Zen Gardens retained premier project management to oversee the work of Scholt Industries performed in a construction capacity. Moreover, PPM reported to Zen Gardens the status of the Zen Gardens project. So somewhere in there, they worded it in a weird way because that's very similar, but slightly different. Okay. The next part that they don't dispute is that the initial contract with PPM was to run for 12 months for the period of construction for the whole project. Zen does not dispute the fact that PPM does not have any employees and Shaw is its sole owner. Zen does dispute where Scholt says that the Zen Gardens manager receives defined fees as part of the subject apartment complex, presumably transferred from Shaw personally. And Zen Gardens said that Zen Gardens manager receives compensation from Zen Gardens, a 6-member LLC. I think because they keep trying to act as if Mr. Shaw is the only person that made up Zen Gardens LLC, and that is not true. Okay, then Zen Gardens does not dispute the fact that Shaw or one of his entities also receives an asset management fee from Zen, which is paid quarterly. Zen Gardens does not dispute the fact that the construction of Zen's apartment complex was Shaw's first project as a developer. Now, this part, so the part you can't see me reading, Scholt said in Shaw's own words, his role during the construction for Zen was essentially as a general contractor role and never got changed. Zen says, insofar as Mr. Shaw was merely contextualizing his testimony, there he explained his involvement was crucial given Scholt's failures, providing, and then he was saying he had to oversee everything. So they just put it into context. Okay. It says, undisputed, Scholt said, echoing the sentiment when asked why Shaw hired him in light of the level of decision-making Shaw admittedly engaged in, Marsau Scott of Scholt explained, in the state of Alabama, you need a general contractor's license in order to build anything, so I'm unaware of Vishal Shaw having a general contractor's license. So Zen is saying they don't dispute the fact that Marsau Scott said that in his deposition. They also don't dispute the fact that Shaw has never held a general contractor's license. He was not trying to act as a general contractor. So yes, they don't dispute that. He was not trying to have one. They do dispute the fact that Scholt says at least one potential lender noted Shaw viewed himself as and wanted to be the general contractor, writing in an email to Shaw, oversight is good, but it sounds like you are really wanting to be the GC yourself with another credentialed GC under you. And they dispute that. Zen does, saying, insofar as plaintiff implies Mr. Shaw wanted to be the project's general contractor. As Mr. Shaw testified over and over again, he served as the project's construction manager. Then Zen disputes the fact that Scholt was trying to say Shaw was aware of the degree of experience Scholt and Scott possessed regarding multifamily construction. Zen says Mr. Shaw testified only that he had knowledge to an extent that Marsau Scott and Scholt had limited experience in the multifamily project of this size, and that the Zen Gardens project could be his, and his meaning Scott and Scholt's, first multifamily project of this size, not ever, just of this size. Zen does not dispute the fact that during the pre-construction process, which involved bidding and negotiating, Shaw worked with Scholt to reduce the total cost of the project. They agree that that is what they did. They worked with him to reduce some costs. Okay, and they'll go more into detail, so I won't say it. Scholt tried to say, consequently, Shaw and Scott both presented contractors to each other with whom they each wanted to work and had several conversations with respect to the numbers and really negotiated hiring. Zen says while Zen eventually met some of Scolt's subcontractors, Zen did not present Scholt with any of his own. Further, it was Scolt's responsibility to furnish qualified subcontractors under the contract's terms. Okay, and I did highlight that, which means I probably wanted to show that to you. It says page 00152. 1 second, let's get there. It's a little delayed. Sorry about that, but okay, let me get down to 001. I might have left myself a note. Yeah, because I didn't highlight it, which means I did not find what they were quoting. If I didn't highlight it in that same page, something was off on how they. Oh, okay. I made myself a 00151 note. So let's go up one page and see. Okay, y'all, I'm gonna keep going because I don't see what I want to see. Okay, there was a couple times they were off on their reference for me, for my level. Not saying they were off, but for me. Okay, then it says, so Scholt tried to say that Shaw and Scott worked on the bid together for approximately 3 months and they arrived at a number they believed the project would cost based on their collective experiences. Zen says Zen did not work with Scholt to develop its entire bid. Rather, Zen helped Scholt bring down certain costs. Example given, costs associated with certain subcontracting trades and with owner-procured items. So it was a very specific part that they helped them with. Zen does not dispute the fact that Scolt's bid came in at $1.5 million lower than the second lowest bidder. And Zen says they don't dispute that to the extent Scolt's bid was the lowest and most responsible based on the figure and qualifications Scholt presented. Thank you for the super sticker, Sweet Rose. How are you? Hey, Auntie Maritha. Welcome to the Trendy Tribe, Stacy Belton. I'll have to pop the trunk for y'all at the end. You know they're going to be fussing at me. But I will pop that trunk for you. Okay. Let's see. Now, so Scholt is saying that Shaw admits to meeting at least a few of Scolt's subcontractors prior to the project's commencement. And Zen says they do not dispute that fact, that Mr. Shaw met a few of the subcontractors Scholt hired before the project began. Then it says, so Scholt said when asked whether he negotiated pricing with any of the subcontractors he met, Shaw initially testified not. Hold on, how do I? We're having a user limitation going on here. Hold on. Sorry, y'all. There we go. Is that what I have to do? Okay. Not directly. Okay. I had to learn something new on PDF. When I'm editing it, I see it all. Okay. And they Zen does not dispute that fact that he initially did testify that he did not negotiate pricing with some of the subcontractors. Then Scholt says, however, in an effort to give lenders confidence in the project and contrary to his sworn testimony, Shaw represented to lenders he met all subcontractors. Zen disputes that and says, Mr. Shaw testified this sentence contained an error. Rather, when Mr. Shaw made this statement, he was referring to major subcontractors who performed work on the project, including those who performed plumbing, electrical, framing, and concrete work. Okay. Then Scholt says Shaw also represented to the lenders he would be personally involved in a role of construction manager oversight, general contractor for the project. He doesn't dispute. Zen does not dispute that. Then Scholt says Shaw additionally represented to lenders he would be traveling and spending 50% of his time minimum for the project for construction management. Zen does not dispute that insofar as the email contained that statement. However, as Mr. Shaw testified, he believed that he would be on the project's job site as required. Okay. Then it says, Scholt said by the time Scholt was actually hired as general contractor, Shaw had already begun the subcontractor review process. Mr. Shaw, and Zen disputes that, saying Mr. Shaw testified that he, quote, did not have any direct contact or direct contract with the subcontractors. Before Zen awarded Scholt the contract for the Zen Gardens apartment project, i.e. the project. So he only had contact after the contract was awarded. They did not speak with them beforehand, is what Zen is testifying. Then Scholt says, ultimately, Shaw and or Zen hired the subcontractors that worked on the project. Zen says Scholt was, in accordance with his representations and the parties' agreement, supposed to hire skilled persons to work on the project. Only when Scholt failed to meet this obligation did Zen hire entities and personnel to work on the project. For instance, Zen hired MSC in November 2020 only to fill the project manager and superintendent roles Scholt left vacant. The other entities Zen hired were there simply to cure or rectify the poor workmanship of Scholt's hired personnel, be they vendors or subcontractors. Okay. Zen does not dispute the fact that as the project moved forward, Shaw communicated with the Scotts frequently, often daily. Zen does not dispute the fact that even when on site, Shaw frequently had in-person meetings with Scott. Zen does not dispute during these meetings, Shaw and Scott discussed the project, which may include material, invoices, labor, skilled labor, the schedule, everything. Scholt said Shaw admits he did not conduct any due diligence. Zen says they dispute that insofar as this contention calls for a conclusion on an ultimate issue, as discussed herein. This is a question for the jury to resolve. Then Scholt says on February 24th, 2020, Zen and Scholt executed AIA document, which is their contract, between owner and contractor, wherein Scholt agreed to perform certain construction services and furnish certain materials, and Zen agreed to timely pay Scholt for such construction work, services, and materials, all in connection with the Zen apartment complex. That is very important because Zen does not dispute that was in the contract. So as we'll go on, you'll see, obviously, they don't dispute the fact that it's in the contract, but the contract was not fulfilled, obviously. Okay, Scholt then says there is a clause in there that says the contract states contractor and owner waive claims against each other for consequential damages arising out of or relating to this contract. Zen does not dispute that. I'm going to shorten this one. This is a long one. It's more, okay, this one's about damages. Basically, Scholt quoted another clause in the contract about damages, how to claim damages, all that, right? Zen does not dispute that fact, including consequential damages, damages incurred by the owner for rental expenses. Zen is not disputing this. Now, Scholt says, meanwhile, Section 5.1.6 of the contract limits any recovery sought by the owner from the contractor to liquidated damages consisting of a mere reduction of the general contractor's fee. Zen does dispute that. They're going to go into more detail. Zen does not dispute the fact that in March 2020, the notice to proceed was issued at approximately the same time C-19 related lockdown started. Scholt says, despite the notice to proceed being issued in March 2020, the municipal building permit was not issued until June 5th, 2020, because Scholt was not timely provided an adequate set of building plans until late May 2020. Zen disputes that. They say the project civil plans were approved on April 25th, 2019. So that was the year before. And Scholt's receipt of them and any and all drawings were not delayed. In fact, Scholt's timely receipt of the project's civil plans and drawings is evinced by Scholt agreeing to the maximum contract price in December of 2019. Then Scholt says mere months later, in approximately October or November 2020, Zen hired Martin and Kobe. Again, Martin and Kobe were the ones that had to fill in for superintendent and all that stuff. Zen does not dispute that fact. Then it says, Scholt is saying Shaw suggested that Martin and Kobe be put between PPM, Shaw's own management company, and Scholt. Zen disputes this. They say Zen hired Martin and Kobe to supplement the work Scholt was supposed to undertake and failed to do on the project. Namely, M&C were hired to fulfill the superintendent and project manager roles, which Scholt failed to fill. Okay. Then Scholt is saying that M&C purportedly brought skill sets, superintendents, and yet another project manager to the project. And Zen says they dispute this insofar as in October 2020, Scholt had no project manager on the project. And then, oh, hold on, we got a super sticker. Thank you, Teresa Wright, for the super sticker. I appreciate you. Oh, look, I saw the bottom rows of food. We can keep that up there for a while. Okay. Then Scholt says when Shaw hired M&C, Scholt had not missed the third contract milestone, which was the final substantial completion date for the project, even though building plans were delayed and C, complications were ongoing. C being, the panini. This is funny because they are just skipping over the fact that they have missed the milestone 1 and milestone 2. They're just trying to say technically they hadn't missed 3 yet. Yeah, you were already behind. They're trying to hurry up and hopefully not miss 3 by hiring more people, in my opinion. But Zen says they dispute this. Scholt had undeniably missed 2 substantial completion milestones as outlined in the contract and never sought an extension for either, whether due to restraints caused by C or otherwise. Moreover, as addressed in paragraph 39 above, Scholt's receipt of the drawings and building plans was in no way delayed. Then Scholt says, in fact, fairly close to M&C's hiring on August 31st, 2020, in response to Scott's 4-week look-ahead schedule for September, Shaw replied, "Thank you, Marsau. Schedule looks promising with reasonable, achievable activities." Zen says they dispute that. M&C were hired approximately 3 months after that email was sent. Then Scholt says, notably, Shaw's Zen Gardens, in case you come in later, seemingly planned to engage M&C for project management services well before the project began, as early as 2018. Zen says they dispute this. This communication does not evince an intention, only a possibility, and calls for an improper credibility determination. Scholt says, yet Zen did not notify Scholt it was using M&C to supplement Scholt. Zen says they dispute that. Scholt was notified of Zen's intent to supplement Scolt's work. Exhibit 4, letters of default. Let's look at the letters of default real fast. Oh my gosh, this is so bad. Okay, I was laughing. It made me laugh. I should say that. It was bad to me. Here you go, y'all. Okay, so this is Exhibit 4. So here's the letter. February 17th, 2021. It was sent via certified mail. A return receipt was requested, and it was sent via email. It was addressed to Scholt Industries, Inc., to their Nashville address and their Alabama address, also to his email. It says, notice of default under the terms of that certain contract for construction of Zen Gardens Apartments dated February 24th, 2020. Dear Mr. Scott, this firm has been retained by Zen Gardens in relation to its interest in the contract for construction of the Zen Garden Apartments on the above referenced property. Based on information provided to me, Scholt Industries is in default under the terms of the contract for failure to meet the contract time delivery schedule as stated in the contract. I'm paraphrasing as stated in the contract. Specifically, Scholt has failed to substantially complete phase 1 within 6 months from the notice to proceed, and phase 2 within 9 months from the notice to proceed as defined by the above reference section. This failure has caused my client to incur substantial damages. Pursuant to the terms of the First Amendment to the contract signed by you on April 7th, 2020, Zen Gardens hereby provides Scholt with written notice of default. If Scholt has failed to cure the above referenced defaults within 15 days of this notice being sent, Zen Gardens hereby reserves its right as stated in 5.1.6 of the amendment to reduce compensation paid to Scholt. Also, too, recover liquidated damages, and any other remedy provided by the contract documents and Alabama law. Should Scholt fail to cure the said defaults within the contractually prescribed time frame, my client intends to avail itself to any or all of the above described remedies. In addition, my client hereby provides written notice to Scholt of its intent to perform an audit related to the cost of work as defined in Article 11 of the contract. Please provide detailed records, invoices, and accounts concerning costs incurred by Scholt related to the work, as well as substantiation for said costs. Pursuant to this notice, please also provide a detailed itemization of costs incurred along with substantiating documentation on a monthly basis going forward on the first business day of each month. Article 11, 11.1.1 of the contract also provides that you shall purchase and maintain insurance of the types and limits of liability, and the owner, architect, and architect's consultants shall be named as additional insureds. Should you fail to add the required parties as additional insureds under the commercial general liability policy, umbrella or excess liability policy, and workers' compensation policy, as previously requested, my client reserves the right to stop the work until the lapse in coverage has been resolved. A stop of work under this provision, quote, shall not relieve the contractor of any contractual obligation to provide any required coverage, end quote. Please be advised that if satisfactory arrangements are not made to resolve these matters within 15 days from the date this letter is sent, my client will be forced to utilize any remedy available under the laws of Alabama or otherwise to protect this interest. However, while my client reserves all rights under the contract, Zen Gardens is willing to forbear initiating default remedies if Scholt executes a forbearance agreement in a form approved by Zen Gardens containing the following provisions. And just so you know, it says and, so they can't play multiple choice. It has to be all or none. So number one, Scholt to comply with the construction schedule produced by Martin and Colby as attached hereto, and execute a deed in lieu of foreclosure in favor of my client's nominee to be held in escrow, only to be released to my client should Scholt not reach substantial completion in accordance with the Martin and Colby schedule, and fully cooperate my client's audit of Scholt's accounting records related to the work. And should the stated cost be 5% or more than actual cost, Scholt shall beat the cost of the audit in addition to reimbursement to my client for overcharges, and agree to a waiver of the contractor's fee of $350,000 for the stated defaults, in addition to an acknowledgement of my client's rights as reserved in the amendment referenced above, and list my client and the required parties as additional insureds under the applicable insurance policies, and execute an unconditional lien waiver in a form approved by Zen Gardens. I urge you to take advantage of this opportunity that my client is extending to you to remedy this default. To discuss the details of Scholt's default and the proposed forbearance, please contact my office. Okay, hold on. Let me take a sip of water. Okay. We're going to go, I think I'm going to go down. Even if it throws off something, it won't throw it off too much because it applies right now. Because I need y'all to see this. That was the first notice of default. Then on March 3rd, 2021, the first one, let me refresh y'all. The first one was sent on February 17th, 2021. A second notice of default was then sent via email now to Scholt's attorney, Marsau's attorney, on March 3rd, 2021. That's to Mr. Alan Anderson. That's Marsau's attorney. Second notice of default. It's addressed to Alan. That's the lawyer. This letter serves as a notice of default under the contract for construction of the Zen Garden Apartments on the above referenced property. Scholt has failed to substantially complete phase 3 as defined in the contract within that time frame. Therefore, pursuant to the terms of the contract, Zen Gardens hereby provides Scholt with this written notice of default. If Scholt has failed to cure the phase 3 default within 15 days of this notice being sent, Zen Gardens hereby reserves its right to reduce compensation paid to Scholt recover liquidated damages, and any other remedy provided by the contract documents and Alabama law. Should Scholt fail to cure the said defaults within the contractually prescribed time frame, my client intends to avail itself to any or all of the above described remedies. Oh, I forgot to highlight this. It says, let me see. Furthermore, in response to your letter dated March 2nd, 2021, please know that my client refuses Scholt's request to withdraw the previous notice of default concerning your client's failure to substantially complete phases 1 and 2 within the contractually agreed timeframes. Now we got to go to April. Now we're in April. April 6, 2021, notice of audit. This is to Alan again, Bottom Row Soul's lawyer. Alan, this letter serves as notice of my client's intent to perform an audit pursuant to the terms of Article 11 of AIA Document A102-2017. Specifically, Article 11 provides that the owner and its auditors shall be afforded access upon reasonable notice to audit and copy Scholt's records, accounts, documentation supporting accounting entries, books, job cost reports, correspondence, instructions, drawings, receipts, subcontracts, subcontractors' proposals, subcontractors' invoices, purchase orders, vouchers, memoranda, and other data relating to the contract. Please note that this letter serves as such reasonable notice for the above referenced documents to be made available on a mutually agreeable date within the next 5 business days. Please note this is the second time notice has been provided to your client for an audit, and further failure to respond will result in further action against your client. So there you go. Just so you know, when they're referencing that, they had 2 notices of default, 2 audit notices. That is probably why Bottom Row Soul was depressed. Okay. All right. So then Scholt says MNC was on site from December 2020 to completion in November or December 2021, and it charged Zen approximately $130 per hour. Zen does not dispute that fact. And again, if you came in later, MNC is who had to come in to help Scholt or help Zen Gardens finish the project. Then Scholt says Shaw, Zen Gardens, also ultimately hired the card group and specifically Rushil Chucksy as owners. Zen does not dispute that fact. As owner's representative, the card group and Chucksy oversaw the construction operations or being as an owner's rep since Shaw was in California. Zen does not dispute that. Chucksy would also help MNC in any way if he had extra time. Zen Gardens does not dispute that. Chucksy acted as owner's representative from February 2021 until August or September 2021, and Zen does not dispute. Both the card group and MNC were on site at the same time. Zen does not dispute that. Shaw says, not Shaw, Scholt says, yet another company, Papa Jack's, also helped Zen make payments through his credit card through the local things because each and everything, they're quoting how Mr. Shaw spoke in his deposition. So if I sound broken, the quote is a little broken. Through the local things because each and everything that, kind of in my understanding, we had to do on our own because, where's it go? Because each and everything, in my understanding, we had to do on our own because the contractor was not performing. Zen does not dispute that. Then Scholt says Zen reimbursed Papa Jack's for these services. Zen does not dispute that they did reimburse them. Scholt says while the card group and MNC were simultaneously on site, PPM, Shaw's own company, was now overseeing both of them. Zen does not dispute that. Zen paid the card group $126,000 approximately for its services as owner's representative from January 31st, 2021 through September 30th, 2021. Zen does not dispute that. PPM, Shaw's company, received approximately $350,000. Zen does not dispute that. Zen also hired Hawthorne Residential Partners to provide apartment management. Let me see if I need to open that up. Okay, apartment management services. Zen does not dispute that. Scholt, I'm on number 60 now. Scholt says Hawthorne carried out its apartment management work through Zen Gardens manager as demonstrated in the email address of at least one Hawthorne employee. Zen says They dispute this. They say Hawthorne performed no work through Zen Garden Manager. Plaintiffs Exhibit 14 shows as much. I did not see Exhibit 14. Okay, then Scholt says, despite this heavy amount of redundant hiring related to management and supervision, Zen nevertheless experienced numerous shortcomings during the project as a result of poor planning, as Zen set unrealistic deadlines and overpromised and underdelivered the balance of the, units. Zen disputes this. They say these quotations are not taken from Mr. Shaw. Rather, they are the opinion of the person with whom he was communicating, as Scholt's exhibit plainly shows. Then Scholt says Shaw blamed the cost overruns on any number of factors, including a price increase on many items because of supply-demand situation, general contractor being inexperienced on the project, design and city inspectors' revisions on many items during construction, etc. Zen does not dispute that. Okay. Scholt says, despite blaming C for cost overruns, the Panini, he is of the opinion that the Panini never affected manpower. He did not experience delivery problems in 2020. Zen disputes this in part because they say that Mr. Shaw provided clear testimony on his contentions regarding the effect of C on the project, which I will refresh your memory. Madison County was not affected in the overall construction business and ongoings like a lot of other states were. They had everything been right, how the general contractor and everybody should have stayed organized, it would have gone fine because everybody was building just fine and staying on schedule. Okay, then it says Scholt is saying the last item of work or labor was performed, or the last item of any material was furnished for any building improvement on the project no earlier than December 21st, 2021. And Zen is saying they dispute that insofar as Scholt maintains it completed its work on the project as defined in the parties' contract. Okay. Scholt says similarly, the certificate of occupancy for the last building issued December 2021. Zen does not dispute that. Scholt said Zen withheld and continues to withhold retainage from Scholt in the amount of $275,000 for out-of-pocket expenditures Scholt actually incurred for purchases of material for the project. Zen does not dispute this. I believe if they had gotten what they asked for the audit, they would have gotten reimbursed already for that. Scholt is saying Zen also withheld and continues to withhold the entirety of the general contractor's fee in the amount of $350,000. Zen does not dispute that. They are holding it. Scholt says Shaw's initial reasoning for Zen never paying Scholt the general contractor's fee or any monies whatsoever or otherwise reimbursing Scholt for its expenses for material was the contract milestones had not been reached. And Zen says they don't dispute it insofar as Zen did not pay Scholt because it did not meet its contractual milestones or complete its work under the contract. Then Scholt says, however, at his deposition, Shaw stated Zen never paid Scholt a single dollar of the $125,000 Scholt otherwise would have received upon completion of phase 1 of the project because Scholt did not send an invoice to Zen. Zen disputes this. They say Mr. Shaw testified that Scholt was not paid because it did not meet the contractual milestones or complete its work under the contract. Mr. Shaw's testimony is also clear that Zen never received timely invoices from Scholt, indicating that it had completed the several phases of its work contemplated in the parties' agreement. The next part is Scholt is saying for the same purported reasons, Zen never paid Scholt for the next phase. And Zen says they dispute that for the same paragraph above. Then Scholt says, Scholt in fact provided Zen an invoice for $804,321.35, including a reduced general contractor's fee of $323,000 and a retainage balance of $197,158.99. Zen disputes this. They said Scholt was required in accordance with the parties' contract to provide Zen interim invoices in accordance with dates contemplated in the substantial completion milestones. That to me says they slapped something together and sent it to them at the end saying pay us, but they had no proof of the in-between. Okay. Then Zen does not dispute all the other people that Scholt is saying they paid. They paid the architect, they paid Mr. Shaw, they paid MNC, they paid the car group, they paid the projects. I said the architect. They paid let's see. I think I named everybody. And then it says Mr. Shaw provided Scholt with Shaw's own reconciliation sheet that included the detailed project costs spread out between entire trades. So basically, everybody else goes saying they paid. Zen Gardens agrees they did pay those people because they did their jobs. Okay, so now we're past the disputed, undisputed. We're on to the additional material facts that Zen Gardens is providing. So this is more material facts provided by Zen Gardens. Okay, so Zen Gardens is saying Mr. Scott refused to answer more than 24 questions during his deposition, rendering the same admitted. In spite of this, Zen was able to glean the following from his deposition. Good luck, Zen. Okay, it says Mr. Scott is Scholt's president. He holds a 15% interest in the company. His wife, Latisha Scott, owns the remainder of his shares. Mr. Scott is from Pontiac, Michigan, and it is here where his history of serial entrepreneurship began. That phrase is hilarious because he tried to tell Mel she tried to throw things in the air and saw it stick, and they called him a serial entrepreneur, and it's just funny to me. Hold on, I see so. I know Melody is glad she saw what she saw, and those people, it's good to know what you're looking at. Scammers and thieves. Allegedly. So then it says Mr. Scott began working in the construction field around the year 2000, starting his first business, SOE Construction, which focused on residential construction and home building. Mr. Scott owned SOE and acted as one of its laborers. And they're saying this based off of his deposition, based off of what Marsau testified to. That's what they're saying. So since he said that, they're saying this, this is a fact, because I'm not everything he says is a fact, but they're saying based off of him, that's what he's claiming. And then the next part is around that same time, Mr. Scott and his brother, Maurice, started a second business, M&M Pools. Mr. Scott ran M&M Pools with his brother until around 2004. Yes, well, hold on. He's a scanner. He's a rock star. Yes. Okay. Then it says shortly after Mr. Scott received his BA in business administration from Alabama A&M University, he transformed M&M Pools into Infinity Pools, which eventually became, under his wife's ownership, Infinity Properties, LLC. Much like Scholt, Infinity Properties LLC operates in the real estate and contracting arena. As Mr. Scott put it, Infinity is in the business of purchasing and renovating commercial real estate. At Infinity, Mr. Scott provided contracting and construction services on several of his projects in the Huntsville, Alabama area, including A, serving as a general contractor over the demolition and construction of a commercial property located at 4212 Oakwood Avenue. B, acting as the general contractor over the partial demolition and renovation at 4206 Oakwood Avenue, a commercial building housing 3 retailers. And C, partially demolishing and renovating a property at 101 Lewis Lane. Thank you for the super chat, Marilyn Demines. Bottom row so and 85% Tisha, not 85% Tisha, will be paying Zen Gardens for the rest of their lives. I love it. 85% Tisha is killing me. By the time Mr. Scott sent Zen Scholt's bid for the project on September 27th, 2019, Mr. Scott had approximately 20 years of experience in the construction business, and they're basing that off of his Exhibit 3, which would have been Marsau's deposition. All right, so now it says in the bid, Scholt represented it had a track record of specializing in hotels and multifamily building construction. But that representation was not true. Instead, Scholt had only undertaken one hotel project at the time it submitted its bid to Zen. I'm going to go back to their proposal because I feel like once we get in that proposal, we just got to stay in that proposal. Okay, so I'm going to go over their points, and then we're going to go to that proposal that Scholt submitted. The above notwithstanding, Scholt also represented that its team members had this experience. The people Scholt represented that it had on staff with significant multifamily structure construction experience included Leger Allen, John Carroll, and Mike Scott. Each of these men, Scholt stated, would serve as a project manager. Mike Scott is Uncle Mike, y'all. Superintendent, and construction manager, respectively, on the project, and be physically present on the project site either full-time or 50% of the time. But none of these men performed these roles as Scholt represented. Allen and Carroll were never hired nor stepped foot on the project site, and Mike Scott was relegated to a, quote, remote position, which was terminated shortly after the project commenced. These several personnel deficiencies resulted in subcontractors receiving little to no direction on the project site and tardy orders for necessary materials. Scholt also represented that it had in-house engineers and capabilities to communicate with clients and address their needs. Zen says it did not. It's just a short sentence, 3 words. It did not. Rather, in September 2019, Mr. Scott and his wife were the only members of the Scholt staff. Scholt also included in its proposal several apartment buildings for which it had provided contracting services, including Monarch Apartments. This might be that list that, remember y'all, when Tisha reposted Marsau's thing, he owned this apartment complex with this many apartments. Remember that? So maybe it was Monarch Apartments, Jonathan Drive Apartments, and Hunter Ridge Apartments. That might be in that list that, she posted that like they were doing something. But it turned out Scholt had not performed general contracting work on any of them. Scholt also helped find the project a financier by introducing Mr. Shaw to Eva Bank. Come on, Eva Bank. Zen relied on each of Skolt's misrepresentations in its proposal when it awarded Scholt the contract. In the parties' contract, Scholt represented it would furnish efficient business and administrative supervision, furnish at all times an adequate supply of workers and materials, and perform the work in an expeditious and economical manner consistent with the owner's interest. It did not. Just a 3-word sentence again. They're dropping the gems. As already noted, the supervisory personnel Scholt represented it would use for the job either never came to the project site or were briefly employed in remote positions. Moreover, many of the vendors Scholt hired either did not come to the job site or performed substandard work, which Zen had to remedy. The parties' contract contained terms that predicated Zen's payment to Scholt upon the substantial completion of certain milestones. In accordance with the contract's first milestone, Scholt was responsible for substantially completing the project's clubhouse not later than September 2nd, 2020. Scholt failed to meet this milestone, and indeed, the work on the clubhouse was so poorly executed that it had to be completely redone and at tremendous cost to Zen. Mr. Scott also conceded Scholt failed to meet the second contract milestone in accordance with the contract's terms. Scholt also failed to meet his third substantial milestone. Eventually, Zen had to hire and work in partnership with several persons and entities to ensure the project's completion, costing it millions of dollars. For instance, in November 2020, Zen hired the firm M&C to provide superintendent and project managing services to help shore up the work Scholt was supposed to perform, since no superintendent or project manager had been on site. Scholt never sought an extension for they never even asked for an extension. The laziness it would take that you don't even ask for the time extension because it maybe could have been approved. That's me talking. But Scholt never sought an extension for a substantial completion deadline from Zen as required under the terms of the parties' contract for any supposed delay caused by the response to the panini or for any other reason. Okay, assuming Zen is limited to liquidated damages, it is not limited to recover only $323,000 as Scholt suggests. As Scholt points out in his opening brief, Alabama law requires courts to enforce contracts as written and to give their terms their ordinary and plain meanings. That is very important. Ordinary and plain meanings. There's no talking around in circles, Marsau. That's a good question. I don't know. So they're quoting a case, and it says, hold on. Okay, so they're quoting one of the cases, Chazen versus Parton. It was an Alabama case in 1999. The cardinal rule in Tennessee, as in Alabama, in regard to the interpretation of a contract to ascertain the intention. Oh, I said Alabama, but let me stop playing. I don't know if ALA dot is for the state of Alabama, so let me take that back. But basically it says the cardinal rule in Tennessee, as in Alabama, in regard to the interpretation of a contract to ascertain the intention of the parties and to give effect to that intention consistent with legal principles, it is the duty of the court to enforce a contract according to its plain terms. The language of a contract must be taken and understood in its plain, ordinary, and popular sense. From this juncture, however, Zinn departs from Scholt's understanding of the parties' agreement. Okay, let me see. Scholt argues in support of its motion for partial summary judgment that Zinn can recover no more and, in fact, only set off what is supposedly owed Scholt, then $323,000 based on the contract's liquidated damages clause. This is not so. I love the short sentences. This is not so. Section 5.1 of the parties' contract defines the amount of compensation due Scholt, had it adequately performed under the contract. That clause provides the owner shall pay the contractor the contract sum in current funds for the contractor's performance of the contract. The contract sum is the cost of work as defined in Article 7 plus the contractor's fee. In the immediately following section, because I told y'all Marsau don't read everything. He read a good sentence, or his lawyer read one good sentence. Okay, Shar. Okay, one time, Shar. I'll reread that sentence, y'all. I got you. One time, Shar. I saw your thing. I gotta pop the trunk for Shar and all my new members and everything. One time.
All right, we going. What a money resign. What a money resign. What a money resign. What a money resign.
Shout out to Shar. Oh, I didn't even see you sent the super sticker, Shar. Thank you. Thank y'all so much. Okay, so in the immediately following section, the contract provides that the contractor's fee is $350,000. Therefore, had Scholt performed, it would have been entitled to the contractor's fee plus the costs covered in Article 7 of the contract. Article 7 of the contract provides compensation for various costs incurred by virtue of work performed on the project. But the liquidated damages provision of the parties' contract, which Scholt cited only in part, because that's what they're good for, in its brief, provides the following. If substantial completion is not reached within the time provided in this contract, including approved and warranted extension of time, the contract time, compensation due to the contractor shall be reduced by any amount equal to $1,500 per day or $1,500 per day for each day that substantial completion is delayed. That was the favorite part of Scholt. Okay, they definitely read that part. Then it says, additionally, in addition to and not in lieu of the liquidated damages provision provided immediately above, the contractor has agreed that in the event contractor fails to commence the cure of any default of contractor's obligations contained within this agreement within 15 days, following the owner sending written notification of same in accordance herewith, and to diligently pursue such cure thereafter until the default is remedied, the owner shall be entitled to recover liquidated damages in the amount of, look, say it with me, class, $1 million from the contractor. They didn't want to read that paragraph. It also says the grant of the liquidated damages provision shall begin with the execution of this agreement and continue until 1 year after the issuance of certificate of occupancy resulting from the completion of the work. After 2 months following contractor's completion of work, owner agrees to reduce the amount of liquidated damages under this provision to $450,000. Okay, y'all. They gotta read. The plain language of the parties' liquidated damages clause above provides that Zinn is entitled to both the sum of the remaining contractor's fee due Scholt, as well as an addition $1 million in liquidated damages for Scholt's performance failures. This conclusion is reinforced by other provisions in the parties' contract concerning Zinn's payment obligations to Scholt, which explicitly condition payment on Scholt's performance obligations. The clause above also provides Zen is entitled to further recovery for every day Scholt failed to meet its substantial completion deadline following the total depletion of the contractor's fee. So you can deplete the whole fee, you owe after that. You can't just reduce it to zero. This is why they asked him, did you have legal representation actually review this contract for you? Not Lil Paulette watching on 3 devices. Yes, Black Titanic, hey queen, professional liars. As Mr. Shaw testified in his deposition and Mr. Scott confirmed in his, Scholt did not meet its substantial performance deadlines, and Scholt indisputably never sought an extension from Zen to modify those deadlines. And that is just the worst. You can't do this for this long and not have something in writing where you at least try to request an extension. I don't understand. It was only through Zen's efforts to remedy Scolt's deficient performance and provision of personnel that the project was completed. While Scholt may argue Zen cannot recover this additional sum since Zen received a certificate of occupancy December 21st, 2021, showing that the work on the project was completed and more than 1 year has passed since that time, this conflicts with the contract's plain language. Rather, Zen's limitation to recover the additional $1 million in liquidated damages contemplated above is conditioned on Scolt's actual completion of the work contemplated in the contract. This is clear given the conditional language contained in the clause qualifying Zen's reduction of the amount of damages following Scolt's completion of the work. Here, Scholt did not complete his work, Mr. Scott conceded in his deposition, causing Zen to hire personnel of its own and spend millions of dollars to complete the project. In short, Scholt failed to meet every milestone marking substantial completion of each phase of the project. Its concurrent and overlapping failures, I'm about to steal that, concurrent and overlapping failures ultimately resulted in its inability to satisfy its contractual obligations as it fails to complete the project as contemplated in the parties' agreement. Because Scholt failed to live up to its end of its bargain with Zen, Zen was forced to hire outside help to pick up Scolt's slack. Thus, Zen is entitled to every remedy available to it in accordance with the liquidated damages clause in the parties' contract. This includes the full sum of the contractor's fee, the additional $1 million contemplated in the parties' liquidated damages clause, and every dollar Scholt spent following the total depletion of the contractor's fee to ensure the project's completion. Zen's fraudulent and negligent, they're claiming both. Misrepresentation claim is not ambiguous or vague. The undisputed facts show Scholt misrepresented to Zen the personnel it would use on the project, costing Zen millions. Contrary to Scolt's contentions, there is nothing vague about Zen's fraudulent and negligent misrepresentation claim against it, the assertions underpinning it, and the evidence to support it. Zen contends, and the evidence shows, Scholt defrauded Zen by representing that it would employ and use skilled project managers, superintendents, subcontractors, and vendors to complete its work on the project. This unquestionably did not occur, costing Zen millions of dollars. In its brief in support of its motion for partial summary judgment, Scholt provides no argument that it did not misrepresent that it would employ the qualified personnel it held out to Zen in supervisory roles on the project or hire qualified subcontractors and vendors, that these misrepresentations were material and that its misrepresentations injured Zen. This is because they cannot so argue, because Scholt failed to present this in court with an argument on these points in its opening brief. It cannot raise them for the first time in reply. I highlight that in red. So basically, since Scholt never said they never actually tried to defraud, the way that Zen is saying it, and I don't know, but the way Zen is saying it, you can't say it now. No backseats is what I'm getting. So you never denied that you misrepresented. What Scholt kept saying was Zen didn't do due diligence. Zen didn't do due diligence. But they never said we did not defraud or misrepresent to Zen, and they can't say it now, how I'm reading it. Okay, let's see. It says the 11th Circuit has repeatedly admonished that arguments raised for the first time in a reply brief are not properly before a reviewing court. Woo! In any event, the evidence shows that Scholt represented to Zen that it employed or would contract with people and entities to perform work on the project. These representations to Zen were material because they were integral to the project's success, and that Zen was constantly injured due to Scolt's misrepresentations. Rather, Scholt only argues that Zen's reliance on Scolt's several misrepresentations was unreasonable, given Zen knew Scholt had limited multifamily construction experience, and Zen worked with Scholt to bring down the cost of Scolt's bid. These arguments do not merit summary judgment on Zen's claim here. Under Alabama law, a fraudulent misrepresentation claim will stand where a party can show one party misrepresented, 2, a material fact concerning the underlying transaction, 3, that the other reasonably relied on the party's misrepresentation, and 4, and that his reliance was to his detriment. Excuse me. Okay, it says this is a case example, Sexton versus Bass, Comfort Control Inc. Negligent misrepresentations claims are a species of fraud, requiring a claimant to meet the same elements, save for proving that the party making the misrepresentation did so recklessly or without knowledge. Ordinarily, the question of whether a party's reliance on another's misrepresentation was reasonable is a question reserved for the jury. Moreover, the reasonable reliance standard is considered forgiving to those who have relied on a misrepresentation to their detriment, allowing the fact finder flexibility in determining the issue of reliance based on all of the circumstances surrounding a transaction, including the mental capacity, educational background, relative sophistication, and bargaining power of the parties. In the first instance, no evidence suggests that Zen knew Scolt's inexperience was so severe that Zen knew Scholt would prove so incompetent as to fail to employ and contract with qualified personnel to complete work on the project. Every penny, 41 fit. They were worth every penny. To the contrary, the list of accomplishments and qualifications Scholt provided Zen and its representations in the contract suggested the exactly. Thank you for the super chat, DJ. You know they are good for TV. They showing other scanners that you can't get away with your tomfoolery, right? Mr. Scott was a college graduate who had taken graduate level courses with approximately 2 decades in the construction industry. He, unlike Mr. Shaw, is a licensed general contractor in the state of Alabama and lives in Madison County, Alabama. Again, unlike Mr. Shaw. Moreover, it was Mr. Scott who introduced Mr. Shaw to a local area lender to help finance the project. In his nearly 20 years of experience, Mr. Scott has started and operated nearly a half dozen businesses and touted men on Scolt's staff with even more experience than him in markets more than double the size of the city of Madison. Under such circumstances, Mr. Shaw's reliance on Mr. Scott's representations was more than reasonable. To the extent that Scholt contends that certain of Mr. Shaw's statements events that Zen somehow knew Scolt's limited experience would handicap Scholt entirely from meeting its contractual obligations, that simply is not so, and the inference sought is too tenuous to merit summary judgment. As Mr. Shaw explained in his deposition, he believed that Mr. Scott's inexperience merely prevented him from figuring out how best to bring down costs from his end of the project. So I just want to clarify that when every time they're saying, well, they helped us pick out subcontractors, they did this, they were in on the bid. When Scolt's saying that, what actually seems to have happened is that Zen just tried to help them be more efficient with their costs. They weren't directing them to actually, this is who you have to hire in this. This is how you can they were trying to tell them how their budget could be better. When padding your resume goes wrong, Maria. Moreover, to the extent that Mr. Shaw's representations to others about his willingness to assist Scholt during the project does not by implication mean he believed that Scholt was incapable of meeting its obligations or doubted its abilities. Rather, as Mr. Shaw testified, he was confident in Scolt's abilities, but he also understood why lenders would have reservations about working with an up-and-comer in the construction business. The evidence here shows that Zen, while working with Scholt to help reduce the costs sought by certain subcontractors, believed in Scolt's ability to staff the project and supply it with adequate materials and experienced and skilled personnel which it failed to do. That's what they're saying. Under these circumstances, i.e., where the men running both businesses had limited multifamily construction experience, but significant construction experience more generally, the answer to that question whether Zinn's reliance was unreasonable is not preordained. Rather, the facts here show a genuine dispute on this point, which deserves to be put before a jury. Alabama courts have routinely precluded summary judgment on plaintiffs' fraud claims under circumstances less favorable to those in which Zinn finds itself in now. So basically, they're saying that there are plenty of cases where they didn't even have this much evidence, and it was still found in the person's favor or the business's favor. Finally, to the extent Scholt contends Zinn failed to exercise due diligence in vetting its qualifications, that position is a non-starter. First, such questions are ordinarily reserved for a jury's determination. Further, given the matters above regarding Mr. Scott's background, the parties' respective positions during the pre-construction process, and the extent of Scolt's misrepresentations, Zinn was under no obligation to conduct a deep dive into Scolt's history. That I need that to stick with people. Zinn did not have an obligation to conduct a deep dive into Scolt's history. That is still good due diligence. It still would have helped them, but that legally that does not, hurt them that they did not deep dive into his history. So just want to make sure that that's out there. Specifically, the information Scholt provided Zinn, which was true, was that Scholt had performed construction services for several projects in the North Alabama area of various sizes. I know that Zinn says it was true. I don't believe it. Scholt also represented the people it would, but it did not use for the project, had extensive experience in multifamily construction. Scholt affirmed these representations and further represented in its contract that it would use qualified personnel to ensure the success of the project. I'm going to go down one because that one, I have a different example. Okay. Let's see. Okay, I'm going to go down here. Considering the above, Zinn's reliance here at its absolute worst creates a fact question for the jury. Thus, Scholt is not entitled to summary judgment on this claim. Then it says Scolt's reliance on, I looked up this word, inapposite case law does not foreclose Zinn's right to recover on his other claims. And basically, inapposite, I had to look it up. It means out of place or inappropriate. Thank you for the super sticker, Brenda Wallace. I appreciate it. Hey, Sassy Sweet Tea from the 80 Swassy. I cannot get my words. Sassy Sweet. Y'all, hold on. Let me take a pause. Sassy Sweet TV from the 803. I call it Sweet Tea. Okay. Finally, Scholt contends Zinn's breach of contract, negligence, and set-off recoupment claims must fail because principles extracted from inapposite case law, inappropriate or out-of-place case law, command the conclusion that Zinn's decision to try to remedy Scolt's several instances of deficient performance foreclose its claims, and Zinn, not Scholt, was responsible for the damages Zinn suffered. These contentions are meritless. First, the cases upon which Scholt has asked the court to rely to support its proposition that Zinn cannot recoup any damages based on Scolt's several performance failures have nothing at all to do with the matter at hand. Indeed, as Scholt notes in its supporting briefs, these cases have nothing to do with a developer's ability to recover from a contractor for breach of contract and fraud. Rather, each of those cases examine how a court can impose a duty sounding in tort upon a premises owner who hired independent contractors to perform work on his property. To extend the rules and principles there to the case at bar is entirely unjustified, and Scolt's request for the court to do so is baseless. Just to remind y'all, the case that Scholt tried to cite, oh Lord, that lawyer, that Scholt tried to cite was that if an owner gets too involved and then someone gets injured because the injury was like related to how the owner micromanaged, then that fell back on the owner because the owner had a heavy hand. They changed the relationship, the nature of the relationship, and it was called the servant master. It was a servant master law or case or something like that. And they're saying in Zen Garden's brief that does not have anything to do with what happened here. Yes, the Timu lawyer. Zen says that aside, another issue persists with Skolt's argument here. The party's contract, which is composed of several documents, includes no provision which would prevent Zen, in the face of Skolt's continuous performance failures, from remedying those situations. Indeed, the party's contract contemplates that Zen could fix Skolt's poor work or otherwise carry out work which Scholt failed to timely remedy. Given Zen's clear entitlement to such cure and the inapposite nature of Skolt's cited cases, Scholt cannot argue that Zen somehow signed its own death warrant by fixing what Scholt broke. Skolt's contention that Zen failed to provide it notice that it had performed deficiently is also meritless. Mr. Shaw testified he sent Scholt letters of its default, and letters attached to this brief evince the same, and we reviewed those letters. Give him a white flag. Okay, Exhibit 4, which we're going to get to. Exhibit 4 is the, I think is that the bid? No, that's the letters of default. Indeed, these letters show Zen repeatedly informed Scholt of his failures under the contract and subsequently sought to audit Skolt's books, given these repeated failures. What is perhaps most troubling in Skolt's argument here, however, is that Skolt's main line of attack is simply to cast aspersions, and I looked that word up. Aspersions is an attack on the reputation or integrity of someone or something as Zen and its management and ownership, and question their credibility. As this court is aware, credibility determinations are the province of the jury. Okay. Okay, I'm gonna go back. I'm gonna go down to this case. Hinkle versus Goodyear Tire and Rubber Company. In that case, it says the court cannot resolve this factual discrepancy at the summary judgment stage. A jury will have to determine which of Castille's conflicting versions of events is true, if either. So, as y'all know, there are conflicting events in the depositions, and the jury needs to decide. So they're using that as evidence. I have the word, but I cannot get the word in my mind. I know I have some people in here that know the word I'm trying to think of. When precedence, the case set precedence, that's the word I was thinking of. Okay, so it says here, Scholt does not contend with its own failings. Instead, insists the court should prevent Zen from recovering anything because it tried to remedy Skolt's deficiencies. Scholt whitewashes that it defaulted on obligations in the contract, failed to employ and contract with competent individuals, and tries time and again to fall back on the global response to the panini in the months following March 2020 for its failures, despite the fact Scholt never sought an extension from Zen to meet its contractual obligations. While Scholt may disagree with some of the ways in which Zen sought to cure Skolt's defects, it is for the jury to decide whether the witnesses have offered information credible to support their contentions. Now we're going to go to the bid. That's our finale, is the bid. Okay, let's see. Let's get to this bid, y'all. Y'all ready to giggle with me? All right. So here we go. So this is their bid. So it's it says RFP, which means request for proposal for general contracting services. All right. Here we go. So this is addressed to Mr. Vishal Shah. Again, that's the main face for Zen Gardens. It says it's regarding the request for proposal, and it says Scholt Industries Inc. is pleased to submit a proposal in response to the RFP for general contracting services for the Zen Gardens apartment community. The attached document will outline our approach to the project and address the specific requirements. Okay. It says Scholt has assembled an excellent team. Hold on. I'm sorry. After going through all that, I'm telling you, this is a joke. I'm so sorry. Scholt has assembled an excellent team with over 25 years of experience in construction management and general contracting specific to multifamily building construction. Our company has the necessary knowledge and experience to undertake a project of this size on behalf of Zen Gardens apartment project partners. Our project delivery goal is on time and within budget. We're going to get to the team. I got you the team, Francois. Our team assigned to this project will consist of a principal, senior project manager, project manager, job site superintendent, and project coordinator with a proven track record of delivering general contracting and construction management services specific to the needs of our clients. Our close proximity to this job site provides an additional level of comfort to the project stakeholders during the construction process. That was Marsau that presented this. Purple unicorn, yes. Yeah, copy and paste, Kim. I agree. Shan says Basement Billy and them is the team. All right, so on to the executive summary. We understand that Zen Garden Apartment project partners desires to construct Zen Garden Apartments, which will be a Class A gated apartment community consisting of 120 apartments with an equal mix of 1 bedroom, 1 bath, and 2 bedroom, 2 bath units equally distributed in 5 identical buildings on a 6.4 acre parcel located on the east side of the Slaughter Road in Huntsville, Alabama. Each building contains 24 units with an equal mix of 1 and 2 bedroom units housed in a 3-story wood frame structure. Each building will have 2 ADA compliant units, also having an equal mix of 1 and 2 bedrooms, both located on the ground floor. A clubhouse located at the entrance of the property will contain leasing offices, a tenant lounge, computer stations, recreational areas, fitness center and restrooms, common amenities to include a resort-style swimming pool, sand volleyball, and I did not look this up. Is it Bosch? What is that? BOCCE ball courts. Y'all let me know. I'm gonna try to look out to see who. Type it phonetically. I do not know how to pronounce that. Children's play area, dog park, and a walking trail surrounding the property. Property will also contain 14 covered garages for tenant parking. Approximately 185 parking spaces will also be available for tenant parking, including spaces for electrical vehicle charging. Black Titanic actually did go out there. If y'all want to see some of her video, one of her videos, she went there. I cannot, it's Brian. We also understand that the proposed construction duration for the project is 11 months, 335 days. Oh, thank you, Bachi Ball. Okay, Bachi Ball. Thank you. Okay, 335 days from notice to proceed to be issued on October 15, 2019 to the issuance of certificate of occupancy. Scheduled for September 14th, 2020, which is 30 days ahead of the completion date requested in the request for proposal. While the proposed may not meet the milestones listed in the RFP for the clubhouse in buildings 1 through 3, it does, however, exceed the delivery expectations for buildings 4 and 5, along with the overall project completion date. In our proposal, we have allowed for assumed net revenues associated with projected milestones listed in the RFP. Additionally, we have implemented a strategic approach to delivering the overall project ahead of completion dates listed in the request for proposal in efforts to compensate for the assumed revenue. During construction, we will run multiple crews concurrently to ensure that job site manpower meets scheduled demands in our delivery of the project to the owner. I cannot. The project approach. Our overall project approach carries heightened emphasis in the areas of site logistics and scheduling. Having our project structures dried in prior to the rainy season allows our multiple crews to build concurrently in 3 tiers. A critical component of our schedule will be completion of all building envelopes, which allows us to incentivize interior crews to accelerate the construction overall schedule. An additional critical scheduling component is timely delivery of construction materials to the job site. Thank you for the super sticker, Claudia. The project, as designed, allows for the realization of economies of scale when materials are delivered in a timely fashion. Remember, they did not order materials in a timely fashion, although materials were still available throughout the panini for at least where they were, according to other contractors operating in that area. Without the implementation of this, potential delays are a strong possibility. Our project team will be proactive in ordering required materials, receipt, and staging of delivered material and equipment, the submittal review process, and the assurance that no delays will be realized as a result of same. As an experienced construction team, we understand that we may encounter potential challenges. Our schedule shows an additional 109-day duration in completing the clubhouse, an additional 84 days in completing building 1, and an additional 27 days in completing buildings 2 and 3. However, Our overall project schedule shows completion of buildings 4 and 5 approximately 31 days ahead of schedule, which falls in line with an acceptable substantial completion date. As with any construction project carrying phased completion dates with owner turnover components, site logistics post-occupancy of turned over completed buildings will present a challenge. As a result, it is important for new tenants to enjoy newly occupied units free of traffic congestion due to ongoing construction activities. In our contact with the municipality, the City of Huntsville has communicated to us their requirements for the issuance of required certificates of occupancy. I want to point out, because I did put it in red, that oh no, not the part I put in red, but I wanted to point out that I think that there was an amendment to the milestones that they refer to with those dates, because Zen does refer to the amendment, and I feel like the amendment is because they accepted Scholt's bid, and they might have changed the milestone dates. They still didn't meet those though, either way. Okay, let's see. Knowledgeable of these requirements, we have included the proper paving requirements into our overall project schedule as we turn over completed buildings to the owner. Remember, the only other court case that Zen Gardens has to deal with, or lawsuit, was due to the paving. I just want to point that out. And yes, that was a subcontractor under Scholt. Executed subcontractor contracts will include performance incentives to promote a flexible building turnover schedule. Our site logistics plan will be issued to the owner prior to job site mobilization and will be updated quarterly or as necessary to reflect delivery areas, worksite trailer location, and staging and equipment areas. Our job site superintendent, in addition to our project manager, will be responsible for maintaining the job site and will be available at all times. The project team will also consist of a senior project manager who will be responsible for all construction activities, a project manager who will be responsible for the day-to-day functions of the project, a job superintendent, and a project coordinator/administrator responsible for all project controls. We will implement the use of a project management software to ensure the dissemination of information to everyone in a timely fashion as not to cause, I don't think they meant to type this. I think they meant to say as not to cause delays, but they said as not to cause no delays. Scholt Industries, Inc. is also prepared to initiate outreach efforts to encourage ALDOT certified DBE and certified MWBE contractors and vendors to participate in construction activities. In summary, construction activities for this project will flow as designed. The design is reflective of components which allow for economies of scale to be realized via the scheduling, planning, organization, and logistics allowed for in same. Our goal is to be smart and simple. They got the simple part. And experienced construction anticipates challenges. However, the resolution of encountered issues and implementation of systems in place allows for the prevention of reoccurrence while ensuring an efficient workflow. Okay, so here we go. Site superintendent, they didn't have a name right here, but Uncle Mike would be the senior project manager, and Lajier Allen was supposed to be the project manager, according to how I'm reading this chart. Marsau Scott was the I guess he's the project coordinator, and I don't know who the principal would be. Here's his hourly rate. Remember in the deposition, he was like, the Zen attorney was saying, did you not submit this as the hourly rates? And he was like, yes, but he was like, they don't actually get paid. And then Marsau was like, but they don't actually get paid hourly. Here's the hourly rates they were referring to in one of them. They had other, paperwork, but this is on the bid. So the site superintendent was a candidate. This will be a $53 hourly rate. Project manager. And I see, this is what I'm guessing, because this is where this is not my specialty on this part, but Zen Garden seems that they would pay 100% of the rate for the site superintendent, 100% rate for the project manager, which was supposed to be Lajier Allen. Then look, they put Uncle from Texas, y'all. I didn't type that. On the left, Zen Gardens put Uncle from Texas on here. I just want y'all to see that. Senior project manager, Michael Scott Sr., 50%, $93.75. Then the project coordinator was supposed to be a Scholt staff member. They would go 50-50. And then the principal was Marsau Scott. He would be paid 40% by Zen, 60% by himself or by Scholt. Relevant project experience, y'all. Okay, let me see here. Marsau Scott, Hunters Ridge Apartments. He did a demo. This is what he's claiming. He did a demo and rebuild for a 12-unit apartment. The client was Infinity Properties. That's Tisha's company now. That was his client. His other client was MJS. Now MJS is Marsau. Is it Javon Scott? That's what MJS is. That's his. And it was Monarch Apartments. It was supposed to be a demo, rebuild, and rehab of 60-unit apartment. One of those he had gotten arrested for, per his own testimony in his deposition, because the building was, I guess, so far gone, and I don't know what he did or didn't do. Now, that's the only 2 times we're going to see Marsau listed as far as relevant, what is it called? Relevant project experience. Now we get to, here's Legier. I put them in green because I think they actually may have the experience, but they never stepped foot on the project site. So, but Legier, he did some work on a 3 to 7 stories, 200 to 650 units, 3 times over. One was in Georgia, Florida, and Texas. Then we have Uncle Mike, y'all. Here's Uncle Mike. And you see, notice the dollar amounts. For Marsau, $415,000, and then this one was supposed to be $1.4 million. Then we go to Uncle Mike. Uncle Mike is $80 million, $49 million, $42 million, $31 million. So Uncle Mike has done, per this document, 1 Shell Square. That was a revitalization project, which was over 520,000 square feet. He did a middle school. He did a high school and a college. Okay. That was Uncle Mike's experience. Here's Uncle Mike's experience. Like, I'm going to say resume. I don't know for sure what they were referring to it as, but notice I made myself a note. When I scroll down, there is not one of these pages for Marsau Scott. I just want you to see. I just want y'all to know that. Okay. So Uncle Mike's experience: Veneer Construction Management, Senior Project Manager. And that's where he did the high school, the college, the middle school, the elementary school. He also was project manager for URS Corporation and Lewis Jones Enterprises, Inc. He was the VP Senior Project Manager. And his education is Master of Architecture at Tulane University. Okay, New Orleans. Okay. A Bachelor of Architecture, also from Tulane University. His project list is, again, the schools. Then we go to Legier. I'm saying Legier, but I don't know how you pronounce his name, but I just want to say Legier. His experience: he has Town Madison Apartments. He's got he's an estimating specialist for Cortland Partners. He did a intern on-site project manager. He served as a project manager aide. His education was a Bachelor of Science in Engineering with a concentration in construction management. And his project list, we got Ativa Peachtree, Highland Vesta, Cortland West Shore. And these are high dollars too. Ativa Pearland, Ativa, I said Pearland, Pearland, Ativa Farmers Market, Ativa Lakeway. And those were 36.5 million, 17 million, 99 million, 17 million, 37 million, 27 million. What do you say? Uncle Mike has fled to Mexico. He on the witness list, I believe. He got to come back now. Just testify, Uncle Mike. Okay, then the statement of qualifications for Scholt, y'all. Scholt has a track record of success. General building contractor specializing in design, build, commercial build-outs, remodeling, renovation, and federal contracting. Scholt Industries, Inc. demonstrates the value of long-term relationships, both internally and externally, in producing a superior project. Our in-house capabilities allow us to deliver highly competitive, quality construction work, and we believe this demonstrates our integrity and dedication to our work. We believe that proper planning and communication is key to a successful installation. Another copy and paste. From contract award to project closeout, our team is in constant communication with our distributors, construction managers, subcontractors, engineers, and our clients. Okay. It says we want to build things, big things that comes from dreams, big dreams. Why does it sound like it came from a song? I don't know if it did. But why does it sound like it came from a song? Okay, let's keep going. I got a little bit more on here. This is the last document, though, y'all. Look, we're in the pages of the last document. As a licensed general contractor, Scholt Industries, Inc. offers a variety of services and project delivery methods for commercial, retail, residential, and multifamily construction, including design, build, construction management, and estimating. It says setting the standard for excellence I am done. I can't write. I cannot. I'm still here. StreamYarding. It waited a while, but it booted me. I'm gonna put it back up on the screen. It's too late now. I done shared most of it. It is too late now, StreamYard. Let me get this back up. Where is my thing? Okay. That's what oops. Candy, that's what I think too. They need to stop. Okay, we're back. We are still here. Okay. Setting the standard for excellence. Then in this part, it says Scholt Industries Inc. has the capacity to take projects from start to finish, streamlining the process, enhancing collaboration, and saving significant time and money for our clients. Oh my gosh, the irony of it all. Current project sample, Uptown. That's blaque, right? I think that's the only thing that got finished. That's blaque, I believe. I know y'all gonna tell me. Blaque is at least part of the whole Uptown name, I guess, or whatever. But yeah, that's the only pictures they had on this this proposal. Well, of buildings that look like they did it. Just should have stuck to property preservation. Then, under construction management, Scholt Industries Inc. has successfully completed projects in a broad range of industries. Scholt Industries provides the depth and flexibility to meet clients' needs quickly and effectively. So they got manpower and safety. I had to highlight those because we know about them tennis shoes on the job site. There was no manpower. The logistics were deplorable. Scheduling, and quality assurance, stop it. They said we take construction projects from concept to completion. Then it says we will prepare the construction budget by studying plans, updating any specifications while identifying and projecting costs for each elevation. The line. Okay, that's where I stopped. The rest was they were doing some independent accounting and stuff like that. Oh, y'all, let me pop the trunk for all my people. Thank you for all the super stickers and super chats.
All right, we going. What a money reside. What a money reside. What a money reside. What a money reside.
Okay. Hold on. Oh, thank you, Queen's Jaja, for the cash app. I saw it. For my Leo sister. Thank you. Thank you, Veronica Monroe, for the cash app. I see you. And thank you, Tammy Van, for a good job. I appreciate you. Thank y'all. Yes. And just so you know, I said, let me go look tonight to see if I see any new documents. Scholt has replied to this dispute from Zen Gardens. So they have a rebuttal. And now I want to see if they still try to say in there, even though that Zen Garden said you can't now come back and say you didn't misrepresent yourself because you didn't say it in the initial. I want to know that they say it in their reply anyway. So that will be the next one I look at. So I'll give y'all a date. You know how I lead up to it. I'll let you know so you're not surprised. You have time to try to be here. Thank you. Let's be clear. They all going to jail. Right. Thank you. Hold on. I know I have something for them. Let's see. Oh, it's so many.
Calls. Ain't nobody got time for that. Ain't nobody got time for that. Ain't nobody got time for that.
And when they have to pay these people, or I don't know, they might try to get out of bankruptcy, but it ain't working for everybody to file bankruptcy.
Sorrows, prayers. Sorrows, prayers.
All right, y'all. That's all I got. Ain't nobody got time for that. I appreciate y'all for being here and sticking with me. Woo, y'all. Y'all are the MVPs for sticking with me to go through these documents. Uh-oh. Are you saying it's one of the best in the country, Angela? Uncle Mike, you better testify and tell the truth. Thank you. Thank y'all for being here. Okay. Thank you, Cynthia. I'm going to play the song to see us out, and I'll see y'all in these YouTube streets. Uh-oh. Click, click, clank, clank. I'll highlight your comments until the song ends, and until the next time I see y'all. Bye.
I've been taking my time. Taking all of your time. taking my time.